Hello, everyone. Thanks for joining us for the August month's labor law updates. We apologize that we couldn't have it last week due to the Vinayaka Chaturthi festival, and therefore we had to postpone it. We didn't notice it when we had initially announced the date. With that, we will start our update for this month. It would be as brief as possible. We would be covering certain amendments and ordinances that have been passed, circulars and notifications that have been issued, a few new news items that are cropped in. We would be touching upon things that could affect your business in the did you know aspect, a few case laws, then the compliance checklist. And last, as told to you last time, we would be touching on the code on wages rules in the end. To start with the amendments and ordinance that have come about in this month, the first is following various other states that we had shown you last month. The Punjab government has as well amended the Contract Labor Regulation Abolition Act to include it to 20 or more workmen, from there to 50 or workmen. So only 50 or more contract workers are engaged. A registration will be required. Similarly, a contractor will also need to take a license only if it is 50 or more contract laborers that are engaged in a premises. The ID Act has also been amended in Punjab to increase the Chapter 5B application from 100 to 300. So unless you have 300 workmen or more, you would not need to seek permission for retrenchment, layoff, or closure. The compensation payable for retrenchment and closure has been retained the same, but the notice pay has been made 3 months in Punjab. Again, keeping in trend with other states, fixed term employment has been introduced in Punjab just as much as in what is there in other states. The only additional rider clause is that you shouldn't convert any of your existing permanent post to a fixed term employee. That's the only additional clause that has been included in the Punjab standing orders. That's the amendments. It's all in Punjab this month. Gujarat government had given certain exemptions on the weekly and daily hours of work owing to the COVID. This has been now further extended till October 2020 by the Gujarat government. The Himachal Pradesh government and the ease of doing business has taken renewal of various enactments online, and it's also made it automatic. So it's like it's an online process, and you pay the prescribed fees, and it becomes an automatic registration or renewal of a license under various enactments. For that, they have issued a notification. Similarly, the Himachal Pradesh governor has also extended the relaxation that they had already given on the daily and weekly hours of work under the Factories Act, has further been extended by the Himachal Pradesh government as well. The EPFO has issued certain guidelines saying that to enable deceased employees' families to get the settlement immediately, they say that once an enforcement officer gets to know about the death of an employee, the officer should collect details from the employer and then educate the family members of the deceased, the legal heirs, and should try to disperse the amounts as early as possible. Well, there are certain formalities like you need the death certificate, you need the legal heir certificate and all these. So how far this would be practically possible is something we need to see, but at least it's a good initiative that the EPFO has passed on the buck to its own officers to ensure that the family of the deceased employee gets, and they also want an action taken report to be given to their head office. So this is a good move by the EPFO. The ESA has been toying with a concept or a scheme where if a person goes unemployed, they will get around 25% of their wages for a period of 3 months. Of course, there are certain other conditions. We will try to put a few slides in the next month's update on what the scheme and how it works. The scheme has now been extended up to 2021, but further relaxations for the COVID is specifically there till December 2020. Now an employee who is unemployed, he is entitled to get 50% of the wages for a period of 3 months in his lifetime. There is a news item which says that ESI Corporation proposes to increase the existing rupees 21,000 wage limit to 30,000, and proposals have been sent. And going by the news item, they also indicate that even if your salary is above the 30,000, you may be able to give a coverage. But I think that requires an act amendment, not merely by notification, whereas the ceiling can be changed by a notification. The Jharkhand government has been extremely progressive in this to permit Tata Steel to switch to a 12-hour schedule. They're specifically given it only to Tata Steel, and so that because the number of employees there is quite high, and they've ensured that for the COVID situation, the number of employees who enter or exit the factory and the exposure that is there is limited by having a 12-hour schedule. So a specific exemption has been given by the Jharkhand government. A similar exemptions, at least for large organizations, even other state governments should consider, is what is our view on that. This is again something to do with the ease of doing business. The Karnataka government has provided that a factory license could be up to 10 years. So if you go get a factory license today, it will have a 10-year life, or it could go even up to 15 years. Provided you pay the prescribed fee. So you don't need to go every year, or once in 3 years was what Karnataka had. So once in 3 year renewal, you don't need to go. Now it's once in 10 years that you need to go for a renewal. The central government, in order to make the state governments initiate labor reforms, has provided that the state governments can borrow additional funds of up to 2% if they implement specific labor reforms. So, for instance, the Karnataka government, taking a cue from this, has initiated processes where it will go online with its registrations under various enactments. Again, like how the PF already done by the EPFO, it has also gone into a computerized central random inspection in respect of 9 enactments. So under 9 enactments, unless the system tells the inspector to go and inspect, the inspector cannot go and inspect an establishment. And it's going to be a computerized central system which is going to be developed. So for these kind of labor reforms, the central government is permitting the state governments to borrow. So every one of us could try to get the respective state governments to do something and tell them that such funds are available. Employer bodies especially could make use of this. The government last year introduced an enactment called the Transgender Persons Protection of Rights Act 2019. They have now circulated a rules with regard to this act. This act came into force on 5th December 2019. It is also applicable to private employers and establishments. It is not only to the government organizations or government departments. Employers are to ensure that there is no discrimination in employing transgenders. The act says that the government can cast obligations on establishments. For instance, the rules that have now come for require a separate washrooms be kept in every establishment for transgenders. So that's one of the proposals in the draft rules that have been circulated now. So going forward, even private establishments may need to provide for washrooms specifically for transgender. We thought that it is a compliance issue that would crop up soon, and employers should be aware of it, and therefore we brought it. The act also requires the employer to nominate a complaint officer to redress their grievances. Therefore, just like how you have a internal complaints committee under the POSH Act, you would need to have a complaint officer here who could look into this complaints that a transgender person could have. So this is a new enactment that came in last year, and the rules have been circulated. There is obligations on the employer under this act. Moving forward to our next section on case laws. Of course, this is a judgment that came last year, but we thought it's an interesting one, which of course we handle it from our office, is where a contract employee raised a dispute on the principal employer, and it was challenging a termination order which was issued by the contractor. So a writ petition was filed, and the Madras High Court held when the termination was order been issued by the contractor, and ESI, PF, everything has been paid by the contractor. There's no question of the principal employer being party to that dispute. And therefore, the High Court held that the Labor Court can proceed only against the contractor and deleted the principal employer from the dispute. There have been queries as to whether we could terminate during the pandemic. Some employers have terminated during the pandemic, especially for misconducts. The Delhi Division Bench of Delhi High Court has clarified that the restriction on termination during pandemic doesn't pertain to misconducts, and certainly not one which had already been committed prior to the pandemic. So in those cases, the Delhi High Court has said the employer is perfectly justified in terminating, and it cannot interfere with such termination. This is again a settled law. Already the Supreme Court as well as the Division Bench of Madras High Court has given various judgments, but despite that, the Provident Fund organization keeps imposing damages for belated payment of Provident Fund. The Madras High Court in this case has again reiterated that in the absence of mens rea or actus reus, damages cannot be levied. So this is a case of where the employer pleaded that it is due to genuine financial difficulty. He was unable to pay the Provident Fund contribution on time. The Madras High Court, following its earlier orders, has held that damages cannot be levied when there is a genuine financial difficulty which resulted in the employer not paying the contribution on time. This month's complaints chart for the September month, the coming month, it's PF and ESA is your regular payments. Professional tax has to be paid in various states, which are shown there. And the Kerala Shops Welfare Act, Welfare Fund is another additional complaints that you need to look into. Moving on to the draft rules that have been circulated by the central government on Code on Wages. As you're aware that the Code on Wages has been already become a legislation, but it's not been notified, therefore it is not effective. What has now been circulated is also only rules, and it has not become effective as on date. So neither the Code on Wages nor the rules are effective as on date. The government has circulated the rules and has asked for comments. These rules have been formulated by the central government. Therefore, they are applicable only to establishments to which the central government is the appropriate government. So most private players would not be covered under these rules. The respective state governments would need to form the appropriate rules, and that rules will be governing the most private players. But then there is a tendency in for all state governments to just copy what the central government does. Therefore, there is a good possibility of the same rules being applied by the state governments. What do these rules do? It provides the manner in which floor wages and the minimum wages has to be fixed. The formula which has been already used for minimum wages is now being continued in these rules as well. So it takes a family to be of 2 adults and 2 kids, therefore 3 units, 2,700 calories is taken as a requirement. All these are already been existing. It's been reiterated by the Supreme Court in the case of Raptacast bread. In fact, the rule says that it is pursuant to this judgment that they're taking. But in addition to that, what the rules provide for is that more than the minimum wages, 10% will be taken towards house rent, and 20% would be taken towards fuel, electricity, and other expenditures. And another 25% would be taken towards expenditure of children's education, medical requirements, and recreation. So this manner of fixation could lead to a higher minimum rates of wages, because till now the Minimum Wage Act doesn't prescribe the percentage to be taken. So 10% house rent, 20% of fuel, energy, or 25% of education, recreation. This kind of a split up was not prescribed under the Minimum Wages Act. So the governments had their own methods to derive at these things. These had to be taken in, but not in these fixed percentages. So till now the governments were doing it, but not on a fixed manner. Now this rules make it mandatory to do it in a fixed manner for each. Under each head, there should be a specific allocation in a specific percentage. So that's the reason why the minimum wages could get higher. Earlier, it's only for a scheduled industry that the government could fix wages, but now there is a schedule of not industries, but skills and employments for which the fixation is going to be done. The fixation would be based on geographical area, which is already there. So a city, town, and village, it could be split into a geographical area, and then it could be split into skilled, unskilled, semi-skilled. In these 3 manners, again, the fixation could be happening. So, and in this, it could be for various works that a person would be carrying on. The rules, of course, do say that it would be for 8 hours, and the spread over could be up to 12 hours, is what the rules provide. The questions have been raised by especially the IT and ITES, where they work 5 days, 9-hour weeks. So if you're giving us 8 hours, what do we do? The rules also provide that when a day wages is provided, per day minimum rates of wages is prescribed, you can divide it by 8 to arrive at a per hour rate. So one assumption that could come is part-time employment can be taken care of by this. So you just divide the 8 hours by an hour, by 8, the per day wages by 8 hours. So you arrive at 1 hour wages. So if you're going to employ somebody for 4 hours, you could pay by that. Similarly, if you're going to employ a person for 9 hours, because your commercial Shops and Commercial Establishments Act provides for it, the additional 1 hour can again be brought in from there. And of course, Saturday will be an unpaid day. So in any event, there won't be any loss to the employer on that account. We are today more and more looking at working from home. Office spaces seems to be something, we don't know what the way it's going to be going forward, very less of office spaces. But still the government is on an archaic note, still going on displaying of notices. In fact, they're making it even worse. They're saying the notice should be displayed in a place which the officer specifies. So it's not even the choice of the employer now where he displaces, but the display will also be told by the officer, you put it here or put it there. Hope the officer doesn't say put it outside your managing director's rooms. So this kind of rules is not required. Today we are more in a digital world. The very same rules provide that your wage slips can be sent digitally. So that's the next slide has it, where you would send it by email, you could send it by WhatsApp now. So when you go digital, your wage slip can go in any manner. When you are opening up and you're recognizing it, that the digital method of communication is the more preferred manner, display of notices becomes redundant, and I don't know why they still want to go ahead with it. It should just be made, the contents of the notice should at some point of time communicate it by email or WhatsApp or some manner to the employee. The idea is only that his rights, he should know about his rights. So that is something where these rules have been provided for, we don't know. At the moment, an employer can make certain deductions. For instance, an employee indulges in a strike, or you impose a 3-day wage cut or 8-day wage cut, or some kind of a deduction you make from the salary, and you're required to note it down in a register. But now the rules mandate that you should intimate about the deduction within 10 days of that being made. So if you take a decision today to make a deduction, you would need to intimate the authority about the same within 10 days. If you think an employee has damaged your property or has caused any loss, again, you are allowed to make deductions. You can continue to make the deductions even under these rules, but the rules provide now that you need to intimate the employee about the damages and loss personally, then by writing, then have a discussion with them, and then impose this deduction for the damage or loss. And if you decide to impose any fine on an employee, I think no more, it's not going to happen any longer. You need to go approach the labor department, and the labor department will call both the employer, employee, have a hearing, and then alone you will be able to impose the fine, and that only if they are going to permit you to impose the fine on the employee. So the imposition of fine is no longer an employer's prerogative. It needs an approval or permission of the government authority who's going to look into it. So this, I think, is again taking away some rights that an employer is enjoying, and it is going to be detrimental to the discipline in a workplace. So this is something which needs to be opposed. Employers tend to give advances to employees at times. There is a restriction that only up to 50% of that amount can be recovered in any month, not more than that. So at least 50% of salary should go. This is already there. The only request or suggestion was when, for instance, if an employee is resigning and leaving, and there are not enough months to recover it. So how will an employer recover it? So should the employer pay the money 50% for the last 3, let's assume it's got a 3-month notice period. So he should still pay it and then wait for the employee to repay it at a later point of time. These are things which the rule makers can take into consideration and give some flexibility in this regard. Deceased employee's family, the dues should be settled within 3 months. Would it be practically possible to do so is a question. In fact, again, as I was earlier talking of in the EPFO, will you be able to get the death certificate, legal health certificate within 3 months? Is a challenge, more to the family than to the employer. Of course, maybe we should take it that once an employer's family provides all the requisite documents, the settlement should be made within 3 months. Wage slips is going digital, I've already spoken about it. Another new obligation that is being cast on principal employers here is that you, as a principal employer, should ensure timely payment to a contractor so that he is able to disperse the wages to his employees on time. So if a contractor provides services to you from 1st to 31st of January, for example, then, and his liability to pay wages is by 5th of February, then he could raise a bill on you on 31st and you're bound to settle it before 5th so that he makes a timely payment. See, in many companies, there would be a time frame within which the bill needs to be settled. So you'll have a 60-day, 30-day window where you would say a credit facility is available to you, where you say, I will settle your bill within 30 days. Your contractors and you could have an agreement on that. But now, these rules are going to limit your powers to get such credit. So you would need to settle your contractors if the contractor says, I don't have the money. So unless you give me the money, I will not be able to settle the contract laborers. If that is going to be the stand of the contractor, then you are, as a principal employer, duty bound to settle the bill. The last aspect of this rules is payment of bonus. As on date, there is no obligation on the principal employee to settle bonus of contract employees. This rules are for the first time bringing an obligation on the principal employer to ensure that minimum bonus is paid by the contractor to his employee. So such an obligation comes. Do you want to settle the bonus on a monthly basis with the contractor, or how do you want to do it? It will be a question. It is something that all of you would need to think about. The industry needs to take into consideration that there is an obligation being cast on principal employers for bonus, which was not there under the Payment of Bonus Act. The Code on Wages rules is casting such an obligation on the principal employer. Again, when the Code on Wages itself doesn't cast such an obligation, can the rules cast such an obligation on the employer? Is a question that needs to be considered at some point of time. So this is what we are looking at under the Code on Wage rules. We keep this more as an update program, and therefore, and we want to keep it as short as we could. So please excuse us for not taking questions with you. Please feel free to write to us if you have any questions on what we have said. The PowerPoint presentations would also be circulated in due course. Do join us for the next meet on Saturday, the 19th of September at 4 p.m. Thank you.